Welcome to this fourth webinar. Today, James Montero is presenting. His topic is Legal Insights, Business Instinct. And well, we know James for a bit of time already in the golf group, but I give you a short overview of his profile. So he is the managing partner. Let me see. The managing partner of Mr. James Montero Advocates and Solicitors, and in his 23rd year of practice as an advocate and solicitor of the High Court of Malaya. James specializes in the area of construction, engineering, and energy, including contract advisory, project management advisory, risk management advisory, dispute avoidance, and dispute resolution. James has acted for a variety of clients, both foreign and local, ranging from multinational, government-linked companies, entities, and public and private companies. He is also an paneled adjudicator, I hope that's the right pronunciation in English, sorry for that, with the Asian International Arbitration Center, founding member and past president of the Society of Construction Law Malaysia, and a member of the Malaysian Institute of Arbitrators. He is also on the advisory panel for the Asian International Arbitration Center's standard form of construction contracts, and was part of the team that rolled out the standard form in Johor Bahru in 2017 and the nationwide roadshow in 2019. And of course, he is very popular speaking on panels and doing webinars. Like the one today, I'm looking very forward to that. James told me he has around 1 hour. So let's listen to his presentation first. And in the end, we will have some time for Q&A. So please take your notes so we can run efficiently to the questions, answers once James is done. And with that, I would like to hand over to James. The stage is yours, please.
Thank you very much for a kind introduction, Patrick. I thought for ease of following, what I'm going to speak on maybe the next 45 to 50 minutes, I have prepared about 30 slides, which I hope will be of some assistance. So when Daniel first asked me to consider speaking to this group, I was a bit apprehensive, and that's why it took a while to get back to Daniel. The reason being this, as Patrick has alluded to, my specialization is very, very boutique, very much in the construction and energy and oil and gas industry. And I know that in our Biz on Golf group, we've got a variety of businesses. So, it'll be difficult for me to get out of my comfort zone and speak about more commercial stuff than construction stuff. But thank you anyway, Daniel, for asking me to speak. And I'm not going to speak on any matter relating to construction in view of the audience we have. What I would like to do is to actually talk about survival. And that's why when Daniel asked me to give him a topic, I told him, look, legal insights, business instinct. The instinct of survival, obviously, in this day and age being of paramount importance. If I may start. So starting with health and survival, and obviously in the early days of this coronavirus, the immediate concern for everybody was for a person's health and safety. Subsequently, the virus was declared a pandemic. It is still a pandemic, and it was identified as the COVID-19 to differentiate it from other forms of coronaviruses. Unfortunately, along with a danger to one's health, the COVID-19 pandemic brought with it an unprecedented global economic slowdown, thus impacting not just our personal health and safety, but the health and survival of many businesses and companies. And whilst you might think it doesn't really affect my company or my business, but it might very well affect a company or business in which you are doing business with. So whether you are the person struggling or you're dealing with a struggling business, I hope that some of the issues I speak on today will be something you can take home with you. So the adverse financial and business impact of COVID-19, was further compounded by the oil price war between Russia and Saudi Arabia, which added to the strain faced by businesses. Now, although this price war has been slightly abated because of the March or April agreement between the two parties, that agreement will only last for 6 months. So at the end of that agreement, who knows what will happen to the oil and gas sector again. So there's a lot of uncertainty surrounding the oil and gas sector. And obviously the oil and gas sector always has an impact, both good or bad, on all our businesses. And taking this with the pandemic, it's really not good news. So let me now go into a announcement by our bank Negara of our assessment in the first quarter of this year. I've taken this from the May release by Bank Negara. Essentially, the Malaysian economy moderated sharply to 0.7% compared to the last quarter of 2019, which was at 3.6%. It's quite a severe drop, expected in view of the price war and the pandemic. The services and manufacturing sectors moderated, while other sectors contracted significantly. On a quarter-on-quarter seasonal adjusted basis, the economy contracted by about 2%. The exchange rate at the first quarter, the ringgit depreciated against the US dollar by about 4.9%. And maybe shockingly, large non-resident outflow amounting to 26.2 billion, was experienced by Malaysia. That's a lot of money leaving our jurisdiction. As of May 2020, the ringgit continued to slide against the USD at 5.8%. So, the slide is actually increasing. Although Bank Negara expects the second half of 2020 to be gradually better, they expect to have an improvement. The headline inflation remains significantly affected. And this is the words which I'm not creating. This is words which I picked up directly from the Bank Negara release in May. So underlying inflation is expected to be subdued amid the projections of weaker domestic growth. So the long and short of it is, even our government and Bank Negara is not expecting good things for our country. But having said that, I think the last time I read the Edge, there was some good news where they expect that come next year, Malaysia will experience exponential growth. So what we need to do is to ensure that businesses and companies, or even persons, individuals who are providing services, will be able to survive these next 6 to 7 months and then move on to better things next year. So as I said again, health and survival. So that's what I alluded to earlier in respect of the Bank Negara May announcement. Okay, so many Malaysians, both large and small, were and still are exposed to growing debt. And some companies with very little or up to now no revenue, companies which until recently were not allowed to open, had zero revenue, thus leading to defaults in debt obligations and leading to a real risk of insolvency. Notwithstanding the steps taken by Bank Negara to provide a 6-month moratorium, there is still this risk that ultimately many companies will not survive and will go down the road of insolvency and closing. So some key health and survival questions arising from this predicament, in my view, are whether your business, or if you're not affected, whether your trading partner's business is in distress. Are there any rescue mechanisms that may be deployed to prevent liquidation of your business, or rescue mechanisms that you can actually introduce to your trading partner to make sure that he survives? At the end of the day, the more of us that survive, the better our opportunity for next year. And alternatively, if your trading partner's business is undergoing restructuring exercise, what should you do? What are your options? Now, corporate rescue mechanisms in Malaysia have improved significantly. Our old and somewhat archaic 1965 Companies Act was finally repealed and replaced in 2016 with a new act which came into force in January 2017. With the modernization came updated corporate rescue mechanisms available to companies in 3 forms. What is termed a corporate voluntary arrangement, a judicial management, or an improved scheme of arrangement scheme from the old mechanism under our old 1965 Act. These rescue mechanisms essentially provide a moratorium giving companies time or stricken companies time to attempt a restructuring of its debts. Just some background into the rescue framework, the corporate rescue framework. So when the Corporate Law Reform Committee considered the insolvency framework under the old Act, it quickly came to the conclusion that the existing framework was plainly inadequate. I mean, I'm not sure how the old framework survived the 1987 crisis, the 1997 crisis, you know, and it took us ages to adopt new, more modern techniques to save companies. So in the old days, once a company was in financial distress, the common outcome was usually liquidation. The company would just close. Under the 1965 Act, the only available avenue to a company in distress was a scheme of arrangement, which I think many of you would have heard of, this very famous Section 176. Unfortunately, the then Section 176 scheme of arrangement had a very difficult threshold for companies to meet. Further, creditors always remained suspicious or plainly, you know, abhorrent, as the board of directors in the distressed company remained the same. So can you imagine, they want you to support their restructuring exercise, but the people who made the decisions that put the company into distress are still sitting there. There was very little trust between debtor and creditors, all leading to this one conclusion: the law as it stood under the old Act was in dire need of change. So, so with this new Act, I'm glad to see that companies now have three options should they think they have the capability of restructuring. The first is the Corporate Voluntary Arrangement, the CVA. Now, the Malaysian CVA is modeled after the UK's, the United Kingdom's Insolvency Act, where in the UK it is known as a Company Voluntary Arrangement. I'm not going to take you through the various sections because that would be totally boring and dry. But if you do have the Companies Act with you in your office, you might very quickly want to look at it. And the relevant sections are Section 394 to 402. Now, a corporate voluntary arrangement is a scheme initiated by directors or shareholders of a Sindram Berhad private limited company with no pledge security in place. A debt restructuring proposal is prepared for the consideration of creditors to enter into a voluntary arrangement that is to agree ultimately to a reduced payment of what is usually owed. Now, the beauty about the corporate voluntary arrangement, a company that opts for a CVA is entitled to a moratorium of 28 days, extendable to 60 days. And this gives a company about 2 months or 2 months and a bit to play around to try and convince its creditors, look, if you don't give me a chance, I'm going to go bankrupt. I'm going to go into liquidation. And what does that mean for you guys? You know, that means you guys won't see your money anytime soon. You will have to go through a very painful liquidation procedure. Worse still, if the liquidator is a government servant and not a private liquidator. And ultimately, after a year, 2 years, maybe even 3 years, you might get 10 cents to a dollar or 20 cents a dollar. So this was not great for creditors, nor was it great for a company that could have entered into an arrangement with its creditors, you know, paid them a little bit less, but still carry on and hopefully maintain a business with the current creditors. So like I always say, it's better to get maybe 50 cents to 75 cents in your pocket than end up in 3 years' time with 10 cents to the dollar or 20 cents to a dollar. So one of the paramount factors in the restructuring proposal under the CVA is that it should aim to preserve viable but distressed companies. I mean, companies that got no hope, you know, they're not going to change. But companies where there's a real prospect of return and for the creditors to maximize some sort of return, you know, then these are the sort of companies that should look towards a CVA. As I said, in the real world, it's better to receive some monies and receive it quickly rather than allow a distressed company to go into liquidation and you end up with almost nothing. So the advantage of a CVA is that it is driven with little court intervention, which saves the distressed company legal costs. Having said that, there is a requirement under the Act for the appointment of an independent nominee in a form of a professional insolvency practitioner to supervise the CVA. You know, someone like a professional from PwC, Baker Tilly, you know, your KPMGs. You know, someone that essentially comes in, takes over how the debt is looking, and tries to restructure it and sell it to the creditors, thereby both saving the company and allowing the creditors to take back some money. And obviously, having a moratorium in place provides breathing space to distressed companies to work out alternative arrangements with its creditors, you know, including bank creditors where there's no charge. I'm only going to very quickly explain these schemes. I'm not going to go into a detailed explanation because I'll put all of you to sleep, you know, within 15 minutes. And when I finish explaining the 3 schemes, we will look at various real-life examples, which I've taken from Baker Tilly because I have in the past worked with them. Okay, the next big scheme which allows an arrangement of debt or restructuring of debt is the judicial management. Now, our new judicial management provisions follows the Singapore judicial management process under the Singapore Companies Act. Strangely, we are about 30 years behind Singapore, you know, as per normal. As their judicial management model came into effect in 1987, I'm not sure whether many of you will remember, but the Black Monday financial collapse occurred in that year, and obviously it appears that Singapore was the quickest to react. In turn, Singapore followed the UK model, which was introduced in 1977. So this judicial management concept, if you like, has been around for about 40 years. It's not something completely new. And the fact that it's been around for 40 years shows that it works. And I find it amazed that it's taken that long for something like this to reach Malaysian shores. You know, I mean, we came up with Dana Harta and all that, but how come we never had a judicial management? Okay. So the judicial management process is a process of rehabilitation or restructuring of a company which is placed in the hands of an expert. So in this case, a qualified insolvency practitioner known as the judicial manager will come into the company, again, to come up with a scheme to try and save the company. I'm not going to go through the sections with you, but the relevant sections are sections 403 to 430 of the new Companies Act. The scheme is initiated by an application by a director, or interestingly, even a creditor of the company can actually seek judicial management of that company, which is great. And I will give you an example of how this worked in a case we did sometime last year. Insofar as merits are concerned, the court takes more interest in the process of a JVA than the earlier CVA process. The court will consider whether placing the company under a judicial manager or judicial management, if there is reasonable probability of preserving the business which would serve the interest of creditors better than a liquidation. Essentially, the court will address its mind as to whether or not there's a chance to save the company. In the event, the expert can come up with a bona fide scheme or legitimate scheme. The judicial manager must undertake and prepare a detailed restructuring plan for the organization, where the court will give the company a temporary moratorium of 6 months. Now, once the moratorium is in, creditors cannot sue the company or close the company down. So the company has got this 6 months to try and turn around with the help of this insolvency expert. The beauty of the judicial management system is sometimes 6 months is just not enough. You know, you can come up with a scheme, but you may have certain creditors that will go to court and object to that scheme, and the court will then say, you have to come up with something better. So a further 6 months could be obtained from court, thereby giving the company 12 months in which to try and turn around. And this is something Malaysian companies never had prior to the new act coming to force. I personally like this scheme. With a professional judicial manager, creditors are given some comfort. It is not the same people who ruin the company that's trying to save it. It is a professional that has come in and is coming out with a scheme. You know, especially the banks. You know, the banks might like an independent person coming in and trying to save the company. As we know, many companies go through tough times, especially in unforeseeable circumstances, unforeseeable times like this. Now, having the guidance in the form of an expert does not mean the shareholders or directors have lost control of their assets. It is merely a temporary measure to assist in the long-term health and security of the company. He comes in, he sells the restructuring plan, and then he goes away. The company goes back to the shareholders and directors, if you like. Sorry, I missed that slide, but I've just explained it. Okay, schemes of arrangement. Now, this is where I said previously under the old Act, we had this very famous Section 176. And during the heydays of companies going, into insolvency, a lot of public listed companies, a lot of big companies jump on the Section 176 bandwagon, and a lot of company and corporate lawyers those days made a lot of money under the Section 176. So this is not a new provision, but it's a provision that's been modernized and probably made less complicated than it was under Section 176. So a company under severe financial distress through its director, shareholder, creditor, or even a judicial manager that has come in may apply to court for purposes of sanctioning a scheme of arrangement. A scheme of arrangement is essentially an arrangement between the company, its members, or shareholders, and creditors. The scheme is very much driven by the courts. The courts take an active interest in the scheme by forcing a restructuring exercise where the affected creditors, members, and the company are expected to convince the court and justify the genuineness and workability of the scheme. As the scheme takes shape, the court may give a 3-month moratorium and up to an extension of further 9 months. So under this scheme of arrangement, this 366, Section 366 scheme of arrangement, again, the company may be given up to 12 months to restructure. And I understand that there are several public listed companies as we speak that are now undergoing a scheme of arrangement, especially those in the oil and gas industry. And the court has given them this 3 months to 1 year protection. Now, the relevant sections under the Companies Act, if you would like to look at it, Section 365 to 393. Now, I will just finish by saying a scheme of arrangement does not just restructure debts, but it can go further than that, including injection of additional equity by existing shareholders or potentially new investors, what we know, the layman knows as the white knight. So these are the 3 schemes which have been introduced under our new, or 2 have been introduced under our new Companies Act, and 1 has been modernized. And I think these are great schemes for companies that are facing hardship, but have solid business plans, solid foundations, where they just need a little time to restructure or a little time of protection to get new investors or to get money from other companies to ensure that they keep going. So any one of these schemes are applicable. And the scheme of arrangements obviously is a scheme that the bigger public listed companies can jump on, as I will show you in a minute. Okay, case studies. Now I've taken these case studies from Baker Tilly's corporate rescue team. And in respect of 5-star developments in Ram Berhad, we actually worked with Baker Tilly under the Judicial Management Scheme to save these companies from creditors. And I'm glad to say that we were successful. Ultimately, the court gave us a 6 months protection, and we were able, the judicial manager was able to convince the creditors, along with the white knight that came into 5-star, to allow a restructuring of the debt. So in that case, I have personal experience, but let's take the loaf. Now, many of you will remember this cafe called the Loaf. I think they were in 5 or 6 locations all around Malaysia, including one in Langkawi, and then I think one in the Pavilion in KL. Now, essentially, the Loaf ran 10 outlets, and they were a cafe. they got into trouble with their creditors. Many of the creditors wanted to wind the company up. So what happened was they brought in Baker Tilly under a creditors under a CVA to try and save the company. Baker Tilly came in, applied for the moratorium. They looked at the setup of the company and basically said, the only way we can save this company is to get in a new company to take over the business, right? Lock, stock, and barrel. Because what this company had was all the modern utilities which a modern bakery needed. And more importantly, they were in fantastic locations. They were in KLCC, they were in the Pavilion, they were in KLIA 2, they were in Langkawi. So the nominee in this case, the insolvency expert, was able to come up with this plan, was able to introduce interested parties to come in and completely buy over the business of this company, and whereby the monies which the company made was then used to pay off the creditors. So that is a great example of a CVA, where in a short space of time, getting in this expert, the expert was able to come up with a restructuring plan and save essentially save the creditors and provided this business an outlet to still make some money and get out of the business, if you like. So the boutique 5-star hotel was another distressed project that landed in the Baker Tilly portfolio. And in this case, they went for a judicial management. And the judicial manager was appointed. The judicial manager came in. He managed to get a moratorium. And whilst looking at the restructuring, he came up with a plan to basically save the company. And essentially, at the end of the day, the company was forced to sell the 5-star boutique hotel to a new buyer. But by selling the 5-star hotel to the buyer, it managed to survive. And until today, it's still carrying on business. And that 6-month moratorium, which the court had given this company to try and restructure its business, was enough for the company to come out of that project, still surviving and getting rid of the asset that had put them in jeopardy in the first place. So again, this was the skill of the judicial manager that came in, worked with the existing directors and shareholders, and with the creditors to save this company. In respect of 5-star development, as I said earlier, this was a case where we worked with Baker Tilly, and essentially this was a semi-D bungalow project in Puchong, whereby the sales of the bungalows and semi-Ds were slow, thereby putting the company in distress. A lot of the suppliers and subcontractors wanted to close the company down because they felt that the company was purposely not trying to pay them, but that was not true because the company had not sold down on the bungalows and the semi-Ds. It just didn't have the cash to make the final payments. So in this case, Baker Tilly was appointed. We went and got a 6-month moratorium, and because this company was a licensed company, it's very hard to get a license to develop this sort of projects. A white knight came in, entered into a scheme of arrangement with the creditors, and within 3 months, paid off all the creditors for dollar for dollar. So in the end, the creditors did not lose anything, but interest. Sorry. And I think that's a great example of how the judicial management worked in that case. And I think today, most of the units are now sold, and the company has survived, and it still has its license to develop other projects. In respect of the public listed company, now this was EPCC in the oil and gas industry, and the EPCC was actually a public listed company that, because of the fall in the oil prices, was significantly hit. They still had business, but they had trouble collecting monies even from the oil, from the big oil giants, if you like. And so they entered into a scheme of arrangement under Section 366, and they are still going through that scheme of arrangement. But what they managed to get was a 1-year protection from court whilst they are going through this process. Now, the Loaf, the boutique 5-star hotel, and the public listed company are actually examples. You can go onto the Baker Tilly website and read for yourself. I'm not going to take you through a very lengthy explanation of this, but again, this is an example of how each of the 3 schemes can work in Malaysia and save the company from being liquidated. Okay, now let's look at it from a reverse point of view. Assuming you are not a struggling company or your company is not in distress, but you are a creditor, what are your options? So even if the court does grant a distressed company a moratorium, a creditor or creditors may still file a challenge to challenge a restructuring or even set aside the moratorium in the event it can show that the moratorium is just a scam. You know, they don't intend to do any real restructuring. They just want to buy time for whatever reason, you know, maybe for the shareholders to, or directors to take as much money out of the company as they can, you know, for whatever reason. But honestly, as a creditor, it is useful to review the proposed scheme with an open mind. Like I said, at the end of the day, if the scheme is not a ploy or for delay or an abuse of process, it might be worth looking at it, and you might, at the end of the day, even be able to get back dollar for dollar, as what we did in the 5-star project. So if the restructuring effort is genuine, it really may be worth seeing through. It's better to get some money than getting stuck in the mud in a long liquidation process. And if this is a company which you have had long dealings with, it might be better to take, you know, 75% of what the company owes you and still carry on when times are better and still continue working with this debtor of yours. So in terms of business instinct, so that's my my own personal thoughts on this, and I hope that you can take something back with you. Now, let me quickly move on to winding up protection in Malaysia. Yeah, so due to the adverse economic effects of the COVID-19 pandemic, the Malaysian government decided to implement and introduce some temporary changes to the winding up time periods provided to companies. Basically, the government thought that the existing time periods are very short for companies who are affected by the pandemic, you know, to turn around. So the government ordered that the minimum threshold to start winding up proceedings of a company has been increased from 10,000 ringgit to 50,000 ringgit. So if your debt against this company is less than 50,000 ringgit, you cannot wind the company up. You cannot take winding up proceedings. You can take other forms of execution proceedings if you have judgment, but you cannot take winding up proceedings unless they owe you 50,001 ringgit. Okay, but this moratorium or this interim relief is only until December 2020, and after that it will go back to the norm, where if the company owes you more than 10,000, you can wind the company up. And there's also a significant increase in the time frame in which a company can respond to a statutory demand notice. Now, before you start the winding up proceedings, you must issue a notice under statute demanding that amount be paid to you within so many days, failing which you are deemed to be insolvent. So previously it was 21 days, but the government has now increased this to 6 months, but up to December 2020. Having said that, it is worth saying that there has now been a challenge in respect of the government's directive, if you like, to order this, because these provisions are actually statutory provisions, and the challenge says that in the event the government wants to implement this, they have to amend the statute. So there is a challenge by certain creditors in respect of whether or not these so-called directives by the government even bite. But by the time they finish with this challenge, December 2020 would have come and gone anyway. So it's really a challenge in futility, if you ask me. Okay. Now, I have about 20 minutes left. Okay. Now, as many of you own your own businesses, and you obviously have many employees, I thought I would just touch on one or two aspects of employment law in Malaysia as well. Again, survival of, and not so much survival of companies, but survival of employees. Now, when the government introduced the MCO, the CMCO, and now the RMCO, some effort was taken by the Ministry of Human Resources to come up with some guidelines. I'll very quickly go into those guidelines. The Ministry of Human Resources, MOHR, took positive steps to deal with employment matters by issuing frequently asked questions, what is known as the MOHR FAQ, on employment issues, which included questions on payment of wages and annual leave during the MCO period. And if you don't know about this, these FAQs were issued on 19th, 20th, and 23rd March, and the last one was issued on 31st March 2020. And under these FAQs, the answers set out therein were referred to as directive from the MOHR. This has raised concern with employers and definitely among the legal fraternity about whether the FAQs or directives has any legal binding force on employers. Essentially, where the directive stated that employers shall pay full wages to employees during the MCO period, even though there is no business operation and no work done by the employees. A directive, now one must be very careful, a directive is not a law and cannot be said to be legally binding. And that is the view of most lawyers. The case of Negara National Berhad versus Manfield Development illustrates this point, that a government directive is not legally binding unless it is passed by some sort of legislation or secondary legislation. So the MOHR, obviously, I think politically wanting to come out and look very good, said, oh, I'm coming out with this bunch of directives to all you companies. You cannot take advantage of your employees and not pay them. But essentially, these meant very little because they were merely guidelines, as I will show you. So the question which many lawyers then had to answer was, is the FAQ in itself a directive? Well, the simple answer is no. An FAQ is not a directive. It is merely a guideline issued to the public for purposes of clarifying uncertainties in the law, if you like, but it has no legal bite. The FAQs contain the ministry's interpretation or statements of the current position in employment law when applied to the MCO situation. This interpretation, though, may be challenged in a court of law, either by the employer or the employee. Similarly, the interpretation taken by the Bar Council, trade union, consultant, or private citizen are subject to challenge in a court of law. So unless these directives were passed in legislation or secondary legislation, ultimately they have no effect. So if an employer followed the directive or didn't follow the directive, the employee may still take the employer to court if there was a breach of the employment agreement. Okay, so one of the many questions I was asked whilst I was at home during the MCO, I get friends calling me up, and my close friends don't call me James, they call me Monty. So they say, Monty, 1 month my company has closed down. I got 10 employees. Do I have to pay them? I had so many of these questions over the MCO. Well, so what is the legal basis? Well, pursuant to the Malaysian Industrial or Employment Law, the employer's obligation to pay wages or salary is subject to the contractual terms in the employment contract. So, unfortunately, you have to go back to your employment contract. There is no one answer or one size that fits fits everybody. I mean, many companies have different class of workers within this company. You got the short-term worker, you got the long-term worker, you got the workers on a year-to-year contract, you have got consultants that may not necessarily fall within the definition of worker. It all boils down to what sort of employment contract you have signed with your employees or people who work in your company. But generally, I take this from the case of Syarikat Permodalan Kebangsaan versus Muhammad Johari Abdul Rahman. The industrial court held that salary is the nub of the relationship between a servant and master. Any change to this, whatever the reason may be, totally destroys that relationship. The master ought not be allowed to justify reducing the salary of his servant for the reason that he has insufficient means. A challenge in salary augurs a new relationship, one which a servant may accept or reject freely. That an employer suffers from financial hardship is no reason to force the same upon his workmen. So ultimately, in this country at least, the employee is generally protected. And just because the company has been affected by the MCO or by the oil and gas price war, the company cannot just turn around and say, oh, this month I'm only paying you 50%, or I'm not paying you at all. You know, there is no real justification for that. Again, depending on what is in the employment contract. So the obligation to pay salary is not conditional upon work being performed by the employer or work being done by the employee, unless the employment term provides as such. And I give you an example. In my office, I have 7 staff. You know, 5 of which are secretarial. And during the course of the MCO, they did nothing. You know, there was no work for them. There was nothing to be photocopied. There was no files, physical files to be seen to. But that doesn't mean because they did no work, I had a right not to pay them. So throughout the MCO, I was, or the firm was obligated to continue paying the salaries of all our staff. So again, this is set out in the case of Viking versus National Union of Employees, in which the High Court held that where there is a collective agreement that provided for payment of a fixed rate of a monthly wages regardless of availability of work, the employer may not reduce the monthly wages on the ground that there was no work available as a result of fall in orders. So the team is still very equitable, you know, where you cannot take the whip and whip your employees and say, just because I can't open my business for 1 month, you don't get paid. Okay. And Section 2 of our Employment Act defines wages as basic wages and all other payments in cash payable to an employee for work done in respect of his contract of service. This has been argued to be the legal basis for the notion of no work, no pay, even though the Employment Act does not provide that the employer shall not pay wages where work is not done by the employee. The definition of wages under Section 2 of the Employment Act provides for the items of remuneration that are to be included in the calculation of wages. It must be noted that the words basic wages stand separately from the words payment in cash payable to an employee for work done. So at the end of the day, one cannot say that just because the company is not getting work, the employee will not get paid. That is not the case in this country. So if there's any, if you are unsure, firstly, look at your employment contract with your employees, or if you are an employee, you know, a senior employee yourself, and then, you know, you can, one good tool which a lot of my clients did was enter into a new collective agreement with its employees. I mean, put his employees aside and say, look guys, for 2 months, the company suffered. It's not that we don't want to pay you, but you have to bear the burden with the companies. So can we enter into an arrangement that we pay you 50%? Everybody across the board, everyone takes a 50% pay cut until the MCO is totally lifted. You know, businesses start, we get revenue coming in, and then we can look at paying you back for that 2 months. I mean, there are different ways in which you can sit your employees down and come to a reasonable compromise. And I think in Malaysia, people are more, you know, accepting to enter into a compromise than just say, no, I want to be paid. I don't care whether you close the company down or not. I want to be paid. Now, okay, then this brings into play, insofar as employment contract is concerned, the impact of force majeure. Now, many of you know this word. I think force majeure now appears in most contracts, or most standard form contracts anyway. Basically, force majeure is suspension of obligations under the contract of service But because in my view, because the CMO or it's only for a period of 3 months, one cannot say that it has a long-term effect or an endless effect. If there was a long-term effect or endless effect, then one can say force majeure or even frustration to bring the contract to an end would set in. I don't think that because it's in the short term, one can say that there's been long-term impact whereby you can terminate the construction contract. So force majeure is a feature of contract. So whether a particular contractual clause relieves a party, either the employee or the employer, of contractual liability will depend on the precise wording used in the clause. So the allocation of risk between the parties provided for by the contract as a whole, the circumstances in which the parties entered into the contract, and the situation that has arisen. Now, obviously, if you enter into a very short-term employment contract, say for 3 months for a specific job, then you can argue there's force majeure. But if the contract is for 1 year or even longer than that, I don't think you can say that force majeure is set in, you know, that we are no longer bound by the contract. I think it would be a very hard argument to take. But when it comes to force majeure, or if there's no force majeure, when it comes to common law frustration, then it really depends on the wordings of your contract and the type of work which that specific employee has been tasked with under the employment contract. So it all depends on the facts of the relationship, you know, and each answer, if you like, might be different from fact to fact, or transaction to transaction, or contract to contract. Okay. So I've set out frustration, but I'm really not going into it. It's similar to the effect of it is similar to force majeure. So guys, I'm done. I hope I've left time for Q&A. Patrick, I'm ready for any questions and answers or any discussions. You know, sometimes it's better to have a discussion and get everybody's view.
So thank you very much for that, James. That was very insightful. I would leave it open for everyone. Anyone has a question right now to what was presented, or any other questions in relation to that?
Now, if what you say is true, that means can employees in future in the employment letter, when you employ a new staff, we put in the conditions like that to say that if something like an MCO come around, that we then both agree that we can adjust our pay accordingly. Your pay.
Yes, you can.
You can, right?
Yes.
In the terms of contract or employment.
Yeah, absolutely. A lot of companies now have a collective handbook. You know,
Oh.
A lot of the terms are contained in the handbook, and obviously, as we know, employees just don't read the handbook.
Okay. Then recently, the government wages subsidy, they offer various wage subsidy to companies based on the size of the company, number of employees.
Yes.
They make the company sign an understanding or just take an agreement in application form to say that, oh, if you take the subsidy, you cannot fire staff within this period to this period, they say. Actually, all this doesn't matter if that's the case, because it's all subject to the what you call that, collective agreement, isn't it?
Yeah. If you fire the staff, you will then be subject to the normal labor laws, and they can lodge a complaint to the labor department and ultimately take you to the industrial court. You know.
Okay, that means the government that do the wage subsidy that make you agree to the new thing to say you cannot fire doesn't matter, because it all fall back to the normal work contract, work terms contract, right?
Yeah, correct.
Okay, interesting. Yeah. It's something I learned. Then,
but if you do fire, then the government can claw back the concession. I mean the benefit given to you, lah.
Yeah,
we ourselves signed on to this benefit, and I told my staff, you know, it's not that I'm not going to pay you. I will still pay you, but whatever the government gives me back, I will just give it to you all as your end of year bonus or whatever, lah. You know.
I see. Okay. Also, force majeure, quite interesting. I thought, like you said, that first module may not mean the MCO, right? Based on what you explained.
Yeah. So there are some contracts which have the word epidemic or pandemic. Many contracts don't.
Oh.
So if you were to look at the force majeure clause, which doesn't have all this, one can say that there is no force majeure. But if there is an epidemic or pandemic clause, or clause where it says change in legislation, and you know, things like that, one can try and argue that force majeure has set in, and because there's force majeure, I'm suspending paying you for 1 month or 2 months or whatever have you.
Oh, that
And perhaps this is where the government's initiative to say that, you know, if you're going to do this, then we give you the benefit, that benefit. I think the benefit is 700 ringgit for every employee earning less than 4,000. Then you cannot sack the employee or not pay the employee or suspend the employee or, you know, something like that. Maybe in that circumstance, I don't actively practice employment law myself, so I'm. You know, it's just logical thinking, I guess. Yeah.
Okay, that means we can add that extra clause in the employment contract in future. If there's a pandemic and something, we can choose to suspend payment, or if there's work is suspended or something like that, right?
Yeah, of course.
Oh, very good. I think George has a question. You look in the chat column.
In the what column?
George, long time no see. He has a question.
You want to read it? I can read it, yeah. So George is asking, what are the employer's liability or exposure in their employee, if their employee got infected at work?
Yes. If the employee got infected at work, then I think under the government directive is that the employer has to take responsibility if it opened its business during the MCO period and the CMCO period. Because the directive from the government is don't open, but if you open, you do it at your own risk. So in my case, George, I refused to open my office. You know, lawyers were only allowed to come in if they needed to grab a physical file, but they cannot come in and do work. They had to work at home because I didn't want to expose us to this claim, you know, that we had breached the MCO or CMCO.
Interesting. Okay.
Okay. James, I have one more question. I know it is not your specific area, but like if I don't have the clause of force majeure of this pandemic in a work contract, right? And I want to add it now, that means I need to change a contract, but employees might not want this, right? So what is the process? Would I need to formally fire an employee first? Can I even do that? And, or how do you, how would you do that?
You cannot fire an employee unless the employee
right?
is in breach of
yeah,
his contract.
So how to change it?
It's well, like I said, common sense has to. It's a very good question, Patrick. I think in this sort of cases, common sense will have to prevail. You have to sit down with the employee and say, look, you know, this is something none of us anticipated. If not, you can tell the employee, you know, if not, I have to consider the even worse position of saying that the contract between you and me are frustrated. And once the contract is frustrated, the contract comes to an end. It's determined. But the threshold of arguing a contract has been frustrated is very high, because this CMCO is only it's only for a few months, a couple of months. It was only what 1 month, and then we had the CMCO, or 6 weeks, and then we had the CMCO. So one cannot say that there's been a long-term effect. It's only been a short-term effect. And frustration to bring the contract to an end will not work if it's only a short-term impact. It must be a long permanent impact, almost permanent impact, if you like.
I understand. Yeah.
I have that at the end of my slides. I will share it. You know, after this, I'll PDF it onto our group.
Okay. Thank you very much.
I got a question for James. basically, if under the Housing Development Act, Schedule H,
yes,
force majeure clause in that schedule, and the contract between developer and the buyer. But now developers are going to Ministry of Housing for extension of time.
Yes.
But there's no force majeure. Basically, the question is the developer will be subject to LADs.
Yes.
Because of the delay, the MCO. So because the MOH have no jurisdiction on this matter, and yet they are giving a free ride to the developers, what's happening? Is there going to be a law and so COVID-19 Act or something like that to?
That's a very good question, Donnie.
Parliament not going to sit, so
That's a very
case, right?
Yeah, that's a very good question, Donnie. In fact, I wanted to touch upon that topic, whether or not we should have had a some sort of CMO Act like Singapore. Obviously, we didn't. So there's very little guidance on this sort of issue. But this is a tough one. Now, assuming the project has, in fact, the housing project under Schedule H has gone beyond 3 years, right? And the buyer is entitled to LAD automatically under Schedule H. But because of this force majeure clause, in the event the developer is able to argue that pandemic falls within this force majeure clause, it may actually be able to convince the Housing Buyers Tribunal that it should not be responsible, but I don't think there's pandemic or epidemic in the, if memory serves me right, under Schedule H. I don't know whether you are.
No, that's correct. There's no clause of force majeure, or basically it's a performance.
Right. So if that's the case, then the chips lies where it falls, and the developer will be subject to LAD, unless of course the Ministry of Housing amends Schedule H to give it a retrospective effect to deal with this 3 months. I can tell you that's not going to happen, because even in respect of the earlier case where they granted 1 year extension of time, which the federal court then found to be completely illegal, the Ministry of Housing has not amended the act. So to me, I don't think we're going to see any positive action by them. And unfortunately, the developer will be subjected to that delay and LAD.
Okay, thank you.
Okay.
George, you have more questions?
Yeah, the question under the chat group.
Oh, I saw it added below that. Yeah, okay. So the question is, what about liabilities of a business like a restaurant if their customers get infected while patronizing the restaurant?
This is a difficult one, George, because in the event the restaurant can show that it has followed all of the government directives to implement the safety measures, then the restaurant can argue that it was not negligent or not reckless, if you like. But in the event the restaurant didn't follow, the 2-meter seating or the taking of temperature, cleaning the premises regularly, screening its staff and chefs and cooks and all that, if it breaches the guidelines by the government, then it is negligent and it is reckless, and the customer can take action. But if they didn't, they followed the directive or the guidelines to the T, then I think it's going to be very hard for the customer to take action. Basically, the customer eats at the restaurant at his own risk. Nobody forces you to go in. George, did you get that?
Yeah, thank you. I got it.
But as we
on the restaurant owners.
Sorry? No, yes, Donnie, you're absolutely right. But if the restaurant owner shows that it has taken all of the necessary steps and all that, then the restaurant owner can say that I cannot be held liable because I'm not negligent. It's like, if you get COVID-19, say by going to a restaurant, you cannot automatically say you have to compensate me. Surely you must show that you got COVID-19 because the restaurant had failed to adhere to the strict guidelines or something like that. There must still be this process of reasonableness, Donnie.
So the burden of proof is on the restaurant or the user?
Okay, so the first, I would think the burden of proof is on the customer to show that it contracted the COVID-19 from that restaurant. And once that happens, the burden moves to the restaurant owner. But I think the restaurant owner will be able to discharge its burden to say that I cannot be held responsible because I have not been negligent, because I followed all the regulations, guidelines, the safety mechanisms, whatever have you, correctly.
The critical word is all, right?
Oh,
You
yes.
cannot possibly have covered all.
Well, let's, assuming for the sake of argument, Dodi, assuming that the restaurant has a CCTV and they can show that, you know, they kept strictly to 4 to a table, 1 or 2 meters apart, you know, you have to spray, you know, the kitchen use all the necessary guidelines. I don't see how they can be held negligent, you know. But it'll be an interesting thing to argue if it happens, lah, to be honest.
On the matter of 176, the future, you know, probably next year when there'll be a lot of restructuring, a lot of companies getting into difficulty, insolvency, trades are slow and things like that.
Yes.
What is likely to happen? I mean, is there going to be forgiveness or what? I don't know. Can you give
I think, well, I'm going to look at it commercially, not so much legally now. I think if a company can survive by whatever means, you know, either by restructuring or even having a casual conversation with its debtors to say, just lay off, give me this past few months, or you have to go through one of the 3 schemes which I identified earlier. I think if the company can survive until Chinese New Year next year, then it's a very good chance that they can reap the fruits of next year, because I think a lot of business people think next year is going to be a good year for us, and not just us. I think across the board. Yeah, I mean, you know, hopefully by then the oil price will have stabilized. The vaccine for the pandemic will be widely available. I think China is already going to test it in, you know, among its army. India has just got approval to start testing. I'm not sure about Europe, Patrick. I don't know whether you've heard anything. I think the fallout from the pandemic has shown the world that you cannot just rely on having one point of business in one country. Like a lot of companies, lock, stock, and barrel, had all their eggs in the Chinese basket. So when China was whacked with with its own lockdown, you know, the repercussions was felt all over the world. So I think companies have now woken up that whilst I can have maybe 50% of my production being done in China, I must make sure that if something like this happens again, for example, Daniel, you talked about swine flu just now, right? So if we get hit by swine flu, it's going to affect us for the next 6 months, right? Especially China, yeah, they don't have all their eggs in the Chinese basket. So the good thing is, I think the big companies have seen they need to downsize from China. So maybe have 50-60% of their production line in China and maybe 40% outside of China, which is great for a region like Southeast Asia, you know. So whilst we may be a little bit more expensive than the production cost in China, but ultimately when you even it out, I think for business sense, companies with business sense, they say, look, we need this buffer. If China falls, we need to have a supply chain from somewhere else, which they didn't have. A lot of these big companies just did not have, including the air conditioning companies, because I wanted to get a spare part and they said, boss, China closed down. You're going to get nothing unless you take a second-hand part, you know? So I think that if companies can survive by falling on any one of these 3 schemes, or even, you know, on a reasonable basis, entering some sort of deal with its creditors, next year, we will start seeing better times. I honestly think that.
Okay, any more questions to James? comments? No, I don't think so. Else, well, you all know James. You have his contact details, and we will see him also in the next BOC golfing. Oh yeah, very good. Here, thanks, James. All the contact details here. Feel free to reach out to James with these questions or any potential business, of course.
Yeah, not just lawyers, you know. I mean, I can tell you that a lot of the accounting firms, you don't have to look at the big ones. A lot of the small accounting firms are probably far better equipped than the lawyers to advise you on these 3 schemes. I mean, the lawyers come in as the conduit where you need the court moratorium protection, but a lot of the work is done between you and your scheme arrangers, if you like, the professionals out there. So go speak to your accountants. You know, they might be the best people to advise you.
I really enjoy James. That I didn't know so much, you know. Yeah.
Yeah. I hope it was understandable.
It is. Oh.
It was a good session, James. Thank you.
Thank you. Thank you, guys.
Thanks, James.
Okay, thank you.
Bye, guys. See you all soon.
Bye.
Bye.
Bye.